So we're going to take up Franco Lewis versus Dion Lewis.
Mr. Strickler, can you state your name for the court and in what capacity do you work for Davidson County?
Douglas Strickler. I'm the Director of Security for the state trial courts.
Okay, and how long have you had that job?
I've been with the state trial courts for 24 years. I've been the director for 4 years.
All right, and do you on occasion help out with service of process?
Yes, ma'am.
Okay, and do you sometimes work for a company called Southern Process Service?
I do.
Okay, and what can you tell us about that company, sir?
It's owned by Kevin Williams. I've served subpoenas and summons for him for 7, 8 years. And as far as I know, it's been a really good company.
How long have you served process for Southern Process Service?
About 7 or 8 years.
Okay. Do you understand why you are here today? They're saying that you did not serve Mrs. Lewis. Can you tell the court if you remember how you got the paperwork and what steps you took to serve her?
I do remember serving her. I don't remember if Kevin, the owner, brought me the paperwork. That's the way it normally goes. He brings me the summons and subpoenas and warrants, and I look up the addresses, and then I go out and I make my attempts. And when I was notified of this, I have a pretty good memory. Once I am somewhere once, I always remember. And I looked up the address and the name, and I remember it was early on a Saturday morning. It was a rainy morning, and I remember serving this woman. I remember her coming to the door, and I think maybe kids were there also, but I remember the name and the address, and I remember her answering the door, and I remember serving her.
Okay, sir, can you see in the courtroom, is this the young lady that you served?
You may not be able to see very much. The camera system is not.
I can't see it. I'm sorry.
Well, I think that's important. Can she stand somewhere?
All right, Ms. Lewis, if you will stand and come to the podium, please. Can we close those blinds back there? They be effective. No, the ones right on the back wall, I think, are the ones that are, yeah. Can you reach that? If you can't, that's fine. So. All right, let's see. Can you see her now?
I can see the back of her head, Your Honor.
Okay.
Could you take a step back?
If she could just turn around,
Have her come on up here. Just step right up here. Step right up here, please. This camera will pick you up a little better. So, yes, you're fine.
Okay. Mr. Strickland, Strickler, was she the young lady that you served? I know it was 3 years ago, but is she the young lady you served?
If you don't mind me saying, Your Honor, the camera I'm looking at is from the back of the courtroom. If the young lady could turn around and face the back of the courtroom, I'd be able to see her face. There you go. As far as I remember, it's been 3 years, but that she looks like that was the woman that I served.
Okay, now, are you familiar with court pleadings?
Ms. Lewis, you can have a seat.
Okay. Are you familiar with what summons looks like and what a complaint for divorce looks like, sir?
I am.
Okay. Did you have a chance to look at the paperwork before you served it on her?
Just the cover page. I really don't recall whether it was what it was. I don't read them. I just look at the name, the address, and then where I do my return of service. And
Did you I'm sorry.
no, that's all right. I don't normally read what they are unless I have to. I'm just more concerned of getting the individual and getting it served
But
on
you
them.
but you recognized it as a summons that you were serving on her?
Yes,
Okay. And she, in fact, did you have her sign the summons? That is her name that appears on the summons?
yes, ma'am.
Okay. And attached to the summons, was it did it say it was out of Cheatham County?
As far as I recall, yes, ma'am.
And also attached to the summons, was it a complaint for divorce?
I'll be honest, I don't remember exactly what it said on it.
Okay, well, would normally marital dissolution agreements be attached to a
Objection.
summons?
He's already testified that he didn't know what was attached to the summons.
The objection is to, hold on, Mr. Strickland, I have an objection to deal with. Your objection is to the fact that the question is asked and answered.
The question is asked and answered, and also the question is asking for his opinion as to what would come normally with the service, and you know, he's a service processor. Why he does do that, that is not with what normally comes with the service of process, is not, his opinion of that is not relevant.
Ms. Tech, do you want to respond?
Well, I'm asking him in his normal course of business, would what normally is attached to a summons is a complaint or petition. And maybe
Well, there
I
can be
should
all sorts of
rephrase it.
things that can be served by process. I sustain the objection because I think he's already indicated that he doesn't recall specifically what was attached. The return on the service of summons that was signed by him states that it was a copy of the summons and complaint was served on her, but his memory as far as what that was, whether he remembers specifically that there was a copy of the complaint, you know, he's indicated he doesn't recall. So
Okay.
so I sustain the objection.
Have you ever been accused of serving bad process?
No, ma'am.
Okay. And was that in fact her signature, Mrs. Lewis's signature on the summons?
Yes, ma'am.
What do you normally tell people when you serve them? For instance, what did you say to her when you had approached her?
I would have explained that if this has been a summons of divorce, I would have looked on the front page, saw when the court date was, or if it was, she had 30 days to respond with her attorney, depending on what it is. I give them the court date, where they need to be. I point out the attorney's name and number, and I don't answer specifics other than the court date, the time, the place, the attorney, phone number. I have them sign, and I leave that with them, and that's it.
Okay. Did at any time after that date that she was served, did she attempt to contact you again?
No, ma'am. No one has contacted me other than you.
Okay.
And then years later.
Okay. I don't have any other questions.
Vonneberg?
Yes. The day you served these documents, were these documents in a folder? Or, excuse me, in an envelope?
No, they were not.
Okay, how do you know that they were not in an envelope?
I don't normally serve things in envelopes. I don't recall this being in an envelope. I normally have a stack of summons or whatever. And like when I go to Montgomery County, I probably had 15 to 20 to do that morning. And that would have been, I set a route for myself, and that would have just been the papers right there. And I would have just brought the papers and taken off the top, which would have been the return of service for me, for the clerk's office, and given her whatever I had stapled or paper clipped together that would have been her papers. So I don't recall anything in an envelope.
So you don't specifically, you normally serve 20, how many did you say in a day? 20 to 50?
Oh, no, 15 to 20 on a Saturday morning.
15 to 20.
Yes.
And in this particular instance, you don't recall what the exact paperwork was.
I just recall it being the summons, and I remember serving it, and I remember her coming to the door. I don't remember exactly what it was, to be honest, until.
Okay. And
So-
have you in the past have you served envelopes before?
I don't normally serve envelopes. That's not the way they come to me. They come to me in a big folder, a stack of summons or civil warrants or subpoenas, and they come to me in a folder, and I take them all out. I look up each one on MapQuest. I print out a map, print out my directions, make notes to myself, and then I go and find the people and I serve them. I don't serve things in an envelope.
That is the way that you say they typically come to you. But
That's
in
correct.
this case, you do not recall, correct?
I do not recall it being in an envelope.
Okay. Nothing.
Let me ask this question. I have the file before me, and that return of service of summons is a part of the court record. And it states that on the 16th day of April, 2022, it states that I served the summons together with the complaint herein as follows. And then there's handwritten in by personal service on the defendant, Ms. Lewis, served copy of summons and complaint at 915 Nectar Court, Adams, Tennessee. Would you have written that you served a complaint and summons on her if you did not look at it or knew what you were serving? Or is that just the standard way you?
That's standard return for a chancery, and depending on the attorney in the Chancery Court, that's standard verbiage for that.
So it doesn't indicate, the fact that that's written in doesn't indicate that's what you saw when you were serving her.
That would have been part of the packet, Your Honor, and I did not, like I said, I did not open the whole thing up or read. I don't read the whole thing. I just knew that there was more than just a cover, just a one page. I knew that there was a
Well, I guess
complaint.
that's what, I have to make this decision, so that's why I'm asking these questions.
Yes, sir.
The fact that you wrote that you served a copy of the summons and complaint does not necessarily mean that's what was actually given to her because you didn't open it and read it. Is that what I'm understanding?
Yes, sir. I knew there was a copy. I knew that was all in there. I just don't open it up and read it. And I know
Open what?
in a divorce.
If it
I'm
was
sorry.
if it wasn't in an envelope, what did you have to open up and read?
Well, it would have been the papers would have all been stapled together or paper clipped together. There would have been a thicker packet. A complaint for divorce is normally thicker when I get those, and I know that part of a divorce there's always a complaint and discovery, and then a lot of times there's the questions they have to answer. So,
All right, thank you.
Interrogatories.
Anybody have any questions for Mr. Strickler after what I've asked?
No.
Thank you, Mr. Strickler. You may leave our hearing.
Yes, sir. Thank you.
All right. Mr. Bonenberger, this is your motion. If you want to then put on any other proof you wish to put on.
Yes, sure, I do. I would like to call my client, Diane Jacobson Lewis. Can you please state your name for the court?
Dion Jacobson.
Ms. Jacobson, you and your husband split in when?
We separated the night of July 31st, 2020.
Okay, and originally y'all were working together on a parenting plan.
Yeah, are we investigating the divorce? I mean, this is a very narrow Rule 60 motion. And I'm assuming they're trying to prove some kind of an error here. And if that's the case, then I am a witness because I know exactly what I did and what I gave Southern Process Service and what I gave Mr. Strickler. So, I mean, I just find this.
There are several.
Well, first of all, what's the legal basis of the objection?
That Rule 60 has to be very narrow. Now be construed. It doesn't matter what happened. We're talking about service of process. They have a document that is an NDA that was in fact mailed to her that she has handwritten, received April the 22nd. That is not the document that I mailed. That was served on her. I think.
All right, I'm going to interpret Ms. Tech's argument to say that she's objecting as this information is not relevant to the proceeding before the court. Mr. Bonenberger?
Your Honor, there's a couple things that are relevant before the court. First of all, the main issue is whether or not she got notice, and it is included in the initial Rule 60 motion, which was filed by previous counsel, that whether or not she actually got good notice of the amended complaint. Secondly, whether she got notice of the motion for default. And the third problem comes with the fact that these parties had signed agreements, including a quitclaim deed that was signed 2 years prior to this divorce agreement by the husband, quit claiming the marital property to the wife when they got separated
10 days.
and was filed with.
Can he prove under Rule 60 that there was an honest mistake, you're done? And if that is.
He's making an argument and then responding to your argument about why this material is relevant, Ms. Tech. If you'll let him finish, then I'll consider whether or not it is or is not relevant.
The marital dissolution agreement divides the marital property and puts a sale date on the marital property, saying that they will continue to own it as tenants in common, and makes it tenants in common when the husband had quitclaimed that deed to the wife over 2 years before and they didn't own it in tenants as common. And in addition, the agreements they made as to child support and alimony were not included in the final decree. And nowhere in the final decree does it say anything about the husband's significant retirement that was not divided in the final decree at all.
What you're asking right now
Is to set aside
I know that, but I mean, what you're asking, the questions you're asking that Ms. Tech objected to had to do with these negotiations that had been going on during the previous to the entry of the final decree, correct? Ms. Tech's argument is that a Rule 60 motion is very limited to one of the bases that's set forth in the motion, either mistaken inadvertence or excusable neglect, or the second basis is fraud. And both of those must be brought within 1 year. And then it goes on to talk about other basis. And the final one is for any other justifiable reason that the court finds would be required to set it aside. So my question to you is, how does what you're asking this witness testify about relate to any of those bases for a Rule 60 motion?
Fraud in that he represented, he had an interest in the house that he then had the court divide. Fraud in that he never brought up the signed agreements and contracts that were between the parties.
If you will let him finish, I'm going to give you an opportunity to respond.
we can provide notarized copies of the agreements between the parties that were never addressed in the filing or in the
We
marriage.
understand that an agreement between the parties during a pending case may be considered to be temporary in nature or even negotiations in nature, and that it's not a binding agreement unless it's signed off on by the court. You understand that?
That I understand that, Your Honor, but it should have been, there should have been a motion to set that agreement aside as it was a contract between the parties. The court definitely has a duty, has the ability to set those agreements aside because they are temporary in nature. But I believe that those contracts can be enforced as part of the marital dissolution agreement and have been upheld by courts. However, the fact that those agreements were not brought up and mentioned in the final degree in divorce and set aside indicates to me that they were not ruled on by Your Honor. And the fact that they were not brought up and ruled on by Your Honor is the basis for a Rule 70 motion. It also goes to my client's belief that she was still negotiating her divorce. The way she found out that she was divorced, the testimony will show, is when she received the bill of costs and called the court to ask why this bill is. In her interaction after she received that and called her now ex-husband, I think believes that there was, at least on the ex-husband's part, an attempt to deceive her about what is going on.
All right, Ms. Tech, I will now hear from you regarding this. Mr. Bonneberg, if you'll step aside and let her have the microphone, please.
First of all, I think he admitted that she knew a divorce was pending, okay?
No.
Ma'am, you need to be quiet.
Then you called my office several times.
Talk to her, talk to me.
Okay, I called her several times. I talked to the office again. I don't want to be a witness in this, but if I have to, I will. We talked extensively. I said, you need to get a lawyer. You need to get a lawyer. She knew that the divorce was pending. We've had several conversations about it and about what was going on. And I just, for her now to play dumb about this whole thing is ridiculous. That didn't happen. She got served with a complaint. I know what a complaint is. I've been doing this, as I said, for 32 years. I do this all the time, Judge, and this is the first time someone is saying that I put a marital dissolution agreement to serve. I know that's not how it's done. I didn't do that. She got the complaint and she said on the phone to me several times, what does this mean? What do I have to do? Well,
that makes you a witness in this case.
Yes, it does now.
Therefore, I'm going to stay these proceedings. Ms. Tech, your lawyer, you cannot be a lawyer and a witness in the same proceedings.
Didn't think it would be this way.
And as a result of that, this matter is going to have to be stayed, and we're going to have to allow your client to obtain another counsel to represent him in this matter. We can reset this for later in the month to come back to, since I've already heard from one witness.
Okay.
That would be the most appropriate way of handling it. What about the 29th day of July?
I think that would be fine.
Mr. Bonneberg, Ms. Lewis, step down, please.
I have a final hearing at 9 in Montgomery County that should not take long, but it's one I can't move.
Again, a Rule 16 motion, I don't see how that is proven. There's no fraud here. There's fraud.
Well, let me make sure that we understand. Court has an obligation under the statute to, when I approve a marital dissolution agreement or I approve a final decree of divorce, even on a default basis, to ensure that there is an equitable division of the property. Mr. Bonneberger has raised some issues that indicate that there is some question about whether or not that was or was not properly presented to the court. I'm not saying that that's true, but I'm saying that's an issue that's now been raised that makes potentially the court requires this court to examine more of the detail of the case in order to allow that ruling on that argument. But the argument about whether or not she understood what she had been served with and so forth is clearly, if you have talked with her over the phone, then your testimony is an essential part of these proceedings. And as a result, I'm going to set it for a hearing, whether that, is advantageous to one or the other, or whether either one of you like it or not. I'm going to have to set another hearing. And the question becomes, what day are we going to set that hearing? And I'd like to do it this month while I'm here on my term of court. What about the 22nd day of August?
22nd day of August, I'm wide open, Your Honor, all day.
All right, we'll hear it 22nd day of August
Okay.
in courtroom 5 at the Justice Center in Charlotte, Tennessee.
All right, Your Honor. Thank you.